Hello, my name is Tracy McKenna. I'm a senior surety claims attorney for Liberty Mutual Insurance Company. Today I'm going to be discussing lien discharge bonds. What is a lien discharge bond? When do you need one? How does it work, and how does it differ from a payment bond? Those are some of the things that I'm going to be covering today. Before we get to the bond, however, I thought it might be helpful to provide a broad overview as to the thing that gives rise to the bond, and that's the lien. As I'm sure many of you are aware, the purpose of a mechanic's lien is to protect those who provide labor, materials, or equipment to a construction project. It's a form of security, and it allows those who help construct a project to secure rights to payment. So what does a mechanic's lien look like, or how does it work? Let's assume that we have an electrical subcontractor who's provided labor and materials in connection with a private project, let's say a hotel project. He completes his work, he does not get paid. Among other things, he can file a lien. Since this is a private project, the lien is going to attach to real estate. More specifically, the lien is going to attach to the real property upon which the hotel is being constructed. Now our subcontractor has lien rights, and he can pursue payment via a lien foreclosure action. Many people are under the impression that a public project cannot be liened. This, however, is not accurate in all jurisdictions. There are many states that recognize liens on public projects. States such as New Jersey, New York, and Illinois. The liens might be called liens on account of public improvement, liens on account of public contract funds. The names may vary. However, the purpose of the lien on the public project is the same as the purpose of the lien on the private project, and that is to protect those who help construct the project and to protect or secure their rights to payment. So how does a lien on a public project differ from a lien on a private project? The lien on a public project does not and cannot attach to real estate. Instead, the lien attaches to public contract funds. To which funds does the lien attach? Let's assume that our electrical subcontractor is now working on a public school project. He has an agreement with the general contractor, who has an agreement with the school district or the owner. He again completes his work and again does not get paid. He can, among other things, file a lien. In this case, the lien is going to attach to those funds that are due and owing or to become due and owing the general contractor. So any monies that the school district is holding on account of the GC, those are the funds to which the lien will attach. It's important to note that to the extent there are no monies due and owing the GC, or no additional monies that are to become due and owing the GC, then there are no funds or no property to which the lien can attach. So the surety issues lien discharge bonds in connection with your traditional mechanic's lien on a private project, and also in connection with a public improvement lien on a public project. So when does the surety come into the picture, and how does it get involved with respect to the liens? Many owner GC agreements will require the GC to keep the project free and clear of liens. Similarly, banks and other lending institutions that finance construction projects often require a lien-free project. So if this is the case and the lien is filed, the surety will often receive a call from an agent who says, "My contractor's project just got liened. We need you, surety, to bond off, bond around, remove, discharge, release the lien." So there are any number of ways to phrase it, but the bottom line is that the contractor needs the surety to remove the lien, whether that lien is attached to real estate or to public contract funds. So this is when the surety steps in and issues what's commonly known as a lien discharge bond on behalf of the contractor. So when I hear the word discharge, I think of bankruptcy, and I wonder, okay, a lien discharge bond is issued. Does that mean the lien is discharged, that it's gone? That lien rights are now gone? No, that is not the case. What does happen when the lien discharge bond is issued is that the lien remains intact, as do the lien rights. However, the lien is transferred from either the real estate or the contract funds to the bond itself. So for that reason, sometimes it's easier for me to think of this as a lien transfer bond because that's all that's happening. The lien is being transferred from one property, real estate, or the contract funds to another, the bond itself. So what happens when the lien discharge bond is issued? The real estate title is clear. The public contract funds become unencumbered, and to the extent that the owner has halted payments due to the lien filing, presumably the owner payments can resume. Do enforcement rights change now that the lien has transferred and is attached to the bond? No, the answer is no. The party with the lien can file a lien foreclosure action just as he or she would have done had the lien remained attached to the real property or the contract funds. So those are some of the basics as to the lien discharge bonds, when you need it, and how it works. I would like to also point out two features of the lien discharge bond and also discuss how it differs from the payment bond. The first aspect of the lien discharge bond that I wanted to touch on is the penal limit. So the penal limit, or the total value of the lien discharge bond, is almost always going to be greater than the value of the underlying lien. Excuse me. This allows for interest accrual and potentially costs associated with a lien discharge or lien foreclosure action. Every state is going to differ as to the requirements. For instance, in New York, a lien discharge bond must be in an amount that is equal to 110% of the value of the underlying lien. Again, that's just New York, and each state will have its own requirements. The second feature of the bond that is of interest, particularly to those of us who handle claims, is the recovery provision. So what has to happen in order for the party who filed the lien to recover payment from the surety under the lien discharge bond? So what is it that triggers the surety's payment obligations? There are three specific things that need to happen before the surety's payment obligation is triggered. The first thing that has to happen is the party who filed the lien must file a lien foreclosure action. The second thing that has to happen is that the court has to enter a judgment in connection with that lien foreclosure action. So the court has to find that there is a valid lien and a valid lien in X amount of dollars. The final thing that needs to happen to trigger the surety's payment obligation is that the bond principal, the party who has primary payment obligations, let's assume it's the GC, that bond principal has to fail to satisfy the judgment. So all three of those things need to happen before a surety is obligated to issue payment under the bond. Many who file claims under the lien discharge bond are surprised and dismayed to learn that. Finally, I just want to point out some of the differences between a lien discharge bond and a payment bond. A payment bond claimant does not have to incur the time or expense associated with a lien foreclosure action, something that is essential to recovery under the lien discharge bond. So if you have an undisputed payment bond claim, you are likely to receive payment much quicker and at far less cost. So typically, not always, but typically a claim under a lien discharge bond is going to take more time and cost more money. The other difference between the bonds relates to who can assert a claim. So there are any number of subcontractors, suppliers, laborers who can assert a claim under a payment bond. With a lien discharge bond, however, there's only one party that can assert a claim, and that's the party who filed the lien. So if I'm a subcontractor or supplier, I'm always looking for a payment bond. There is also nothing that precludes a party from filing a lien foreclosure action under the lien discharge bond and at the same time asserting a payment bond claim. We see these kinds of companion claims in lawsuits frequently. So that's it for today. I hope that I provided you with enough of the basics so that the next time someone mentions lien discharge bond, you'll have an understanding as to what it is, when you might need one, the mechanics of how it works, and how it differs from a payment bond. Thank you.